The next case on the docket is BEENE versus BEENE. I'm sorry, go ahead.
That's okay.
Let me start the clock.
If I could reserve 5 minutes for rebuttal.
Okay, go ahead.
May it please the Court, I'm John Mills of Mills, Creed & Gowdy in Jacksonville on behalf of the appellant, William Richard BEENE. This is before the Court on the denial of a supplemental petition to reduce child support and the denial of a motion for rehearing from the trial court's order adopting the magistrate's report and recommendation. The reason given by the trial court is easily dispensed with. The only reason the trial court gave for denying the motion for rehearing was it said it was untimely. That patently was erroneous. The order was entered on July 27th, 2007. The motion for rehearing was served on July 31st, which is within 10 days. And in fact, it was also filed within 10 days on August 3rd. So the trial court should have considered the motion for rehearing on its merits, and it was error as a matter of law to deny that. The trial court also would have abused its discretion had it reached the merits and denied the motion for rehearing, because under this court's clear case law, and I'm relying most heavily on the Zubkin case from 2002, there are insufficient findings to support the magistrate's imputation of income to the husband in this case. There are just a few material findings of fact, and we don't challenge any of the findings of fact made by the magistrate, just the final conclusion. And the key facts are this. In 2003, the husband's child support obligation was reduced to $778 a month. At that time, he was earning $58,000 a year. Subsequently, in 2004, his income reduced to $37,000 when he took a job at his job in the mobile home industry. That right there is a material change.
Counsel, you're citing to testimony before the magistrate?
I'm citing to the magistrate's findings.
Findings. We don't have a transcript of that, though, do we?
No, we're not challenging the magistrate's findings.
Okay.
We have not provided the transcript. If the court would like the transcript, I have discovered, I think it was electronically recorded. We could order it, but we're not challenging the findings, so the court doesn't need to look behind them. In July 2004, the court found that the husband was forced to resign from his mobile home industry job, and also credited the Unemployment Appeals Commission's determination that the resignation was with good cause attributable to the employer. That is a finding, an unequivocal finding of a material change of circumstances. The husband lost his job, and it wasn't his fault. In the answer brief, they say this was a voluntary quit. It was not. The magistrate made no finding it was a voluntary quit, and to the contrary, the magistrate specifically found it was a forced resignation. That's the magistrate's words, and again adopted the Unemployment Appeals Commission's determination that it was cause attributable to the employer. Nonetheless, the trial court said after that he remained voluntarily either unemployed for periods or when he did have employment was underemployed. And that is a circumstance in which it can be appropriate to impute income. And this court's decision in Zubkin is exactly on point. In Zubkin, a surgeon lost his job through no fault of his own and took another job, working 4 days a week. The trial court did not base the order on the actual income earned, but instead found that the surgeon or the doctor, whatever he was voluntarily underemployed because he was only working 4 days a week. The trial court said if he gets another job to work a fifth day a week or more, then he can earn $120,000 instead of the $96,000 that he was actually earning. And so the magistrate based its ruling on the petition to reduce child support. It reduced it, but based on a higher income than the husband was making. This court reversed. It's on all fours with this case. This court reversed because there was no finding of the source of additional income or the amount of additional income. It said that the magistrate had to make, or the judge had to make findings that there was a job out there that the husband could get, and how much that job would make. And because there were no findings, this court reversed, and its reversal directed that the child support be reduced based on the actual income. Did not give a second bite at the apple to come up with findings or to produce more evidence, and we're asking for the exact same result here.
Wasn't there a finding of voluntary unemployment, though?
There was a finding that he remained voluntarily unemployed. There is no finding that his initial losing his job in the mobile home industry was voluntary.
I understand that, but isn't the fact that he remained voluntarily unemployed legally significant?
It is legally sufficient, and I think it would require the judge to make some findings as to, okay, and there were periods of time he was employed, and he made some money, and the court made findings of what he made, and said when he was employed, he was underemployed and could have made more, and when he wasn't employed, he could have made more, or he could have gotten a job. There are no findings as to any jobs out there that were available, what they were, what the amount of income was, and that is required. There is no basis to determine how much income Mr. BEENE should be making if he was, in fact, voluntarily unemployed. And in fact, regardless, even before the unemployment, the trial court made a finding that his income had reduced from $58,000 to $37,000. Even if he hadn't lost that job, that reduction in income, and there was no finding that that was a voluntary reduction in income or that it was anything other than trouble in the mobile home industry. And so even if we didn't have the subsequent issue after he lost that job, the petition still should have been granted even as to the reduction from $58,000 to $37,000. And that's our argument. I'll reserve the rest of my time for rebuttal.
Okay, you have quite a bit left, 13 minutes. Morning.
Good morning, Your Honors. I'm Deborah Johnson, and I represent the former wife, the appellee Stacey BEENE. The appellant, in his first argument, states that the trial court erred in denying the motion for rehearing as untimely. The court clearly denied the motion for rehearing because it was untimely. The time to file for the rehearing or the exceptions to the magistrate's report was July 20th. The magistrate filed her report, served her report, July 10th, 2007. The appellant did not file exceptions or renotice until August 3rd of 2007. Then the appellant represents that he didn't know that he had 10 days to file exceptions to the report. It was served upon the appellant prior to April 9th, 2007, that a referral to the general magistrate requires the consent of all parties, and you are entitled to have this matter heard before a judge. If you do not want to have this matter heard before the magistrate, you must file a written objection to the referral within 10 days. He did not do that. It was heard before the general magistrate. Then the appellant is representing that he didn't know that after the report and recommendation came out by the general magistrate, that he had 10 days to file for a rehearing or exceptions. In the same order filed and served upon the appellant, it states very specifically that you are advised that in the circuit, electronic recording is provided by the court. Should you wish to seek review of the report and recommendation by the general magistrate, you must file exceptions in accordance with Rule 12.490F of the Family Laws of Procedure. You'll be required to provide the court with a record sufficient to support your exceptions, or your exceptions will be denied. None of that was done either. So clearly, Judge Kamansky, who was the trial court, correctly denied their motion to file exceptions or for rehearing as not timely being filed. The appellant is representing that when the hearing was set before the general magistrate and subsequently rescheduled, that he was unaware of all these time constraints to file exceptions, etc. Clearly, the order from the court states all the exceptions in the rules that which he had to comply with. Next, counsel for the appellant was referring to matters in 2003 and 2004. The supplemental petition was not filed by the appellant until December 2nd, 2005. The appellant filed other supplemental petitions, but they weren't filed properly because they were not served upon the appellee. Therefore, the general magistrate correctly stated that it is the supplemental petition filed by the appellant of December 2nd, 2007 that remains in effect. Counsel represents that the general magistrate, made no findings. Clearly, there were numerous findings throughout the report. Specifically, the general magistrate stated that the husband had a job in 2005, which is pertinent because a supplemental petition was filed December 2nd, 2005, but he quit the job in October 2005 after his wages were garnished for child support. And the evidence by the general magistrate also showed that the father, the appellant, did not pay child support when he was employed in 2005 until the wife, the appellee, followed him to his place of employment and issued and filed for an income deduction order. And thereafter, she received one payment, a partial payment, and he quit. He stated that he quit because of the income deduction order. These are all findings by the general magistrate. The general magistrate also found that at no time was a former husband, appellant, mentally or physically incapable of securing any type of employment. Therefore, the magistrate found he was voluntarily unemployed. The appellant's attorney references the Zubin case, which is not applicable to this specific case. The Zubin case regarding a medical professional who sought employment in the medical field. In this case, the appellant worked in the mobile home industry and took a job as a painter. Clearly, they're antithetical to what happened in the Zubin case. Furthermore, the trial court, the purpose of a motion for rehearing is to give the court an opportunity to consider matters which it overlooked or failed to consider. This is in the appellant's case law that was filed in, say, Area Motor Freight Line, 930 Southern 2nd 598. They have not mentioned any error except that the court did not reduce his child support. Further, the court found correctly that there was no sufficient material or involuntarily circumstance permanent in nature. The fact that the appellant quit his job for the sole purpose of not paying child support was rendered in the general magistrate's decision and adopted by the court. The appellant also alleges an abuse of discretion. There was no abuse of discretion because under the case law, it specifically states that there must be evidence to show that there was an abuse of discretion. Counsel has not proved that, has not shown that, has not filed the transcript. Clearly, just based under the judge's ruling incorporating the general magistrate's decision, the appellant, during the times he was working, never notified the court, never notified the appellee, and when his wages got garnished, that's when he would quit his job. The court found that he showed no proof that he wasn't employed. He didn't show any of his applications for employment. He didn't show his current work history. He did nothing to prove that he was unemployed or incapable of not paying the child support as ordered. The court did note that he made no attempt to secure employment during the first half of 2005. We would ask that the court, based on the case law, based on the untimeliness of filing the exceptions and the motion for rehearing, that appellant's action be denied and that the appellee be awarded attorney's fees and costs.
Thank you very much.
Thank you very much.
Okay, thank you.
I don't understand the relevance of much of those arguments. If the court is concerned that some of those arguments would support affirmance, I'm happy to answer any questions.
We don't have any questions.
Okay. Thank you.
Thank you very much.
Thank you very much.
Thank you very much. Have a nice day.
You too. Thank you very much.
Okay.